Volume on full. Good morning, everyone. We're delighted to be joined by Miroslava, who's going to talk to you about AI-enabled price discrimination. Thank you very much. And without further ado, we'll leave it to it.
Yeah, thank you very much. Thank you very much for the invitation. I'm really pleased to be here. This place is very special for me. I was here 2018 as a research assistant, as a visiting researcher, sorry. And I finalized my PhD here in this building. So I'm very happy to be here again. So I am going to talk about AI price discrimination as an exploitative abuse of dominance under EU competition law. So I started working on this topic not that long ago, actually more than 2 years now. And initially I started as a unhappy customer. So like many of us, I experienced what has almost become a cliche of online markets, repeatedly visiting a website to book a flight, only to see that the price increase with each return visit. So the more I examined it, the clearer it became that it's not about dynamic pricing or demand fluctuations, but it was about how digital markets actually collect information about consumers, and then they are able to set up personalized prices. So, as I said, the motivation of the paper was like me being an unhappy consumer. And nowadays, we can see that the algorithmic personalized pricing is now feasible and widely deployed. I consider that we can find strong fairness in consumer welfare concerns, which I'm going to explain a little bit more. But to put the paper into the broader context, I'm going to explain what I consider and whether Article 1 and 2 can be applied to AI-driven personalized pricing. But at the time when I started the paper, I considered this as an enforcement gap. But now I consider it more like a regulatory gap as well. And it's a gray area. At present, algorithmic personalized pricing occupies a gray area, also within the EU digital regulatory framework. At the end of the presentation, I'm going to talk a little bit about a recent development, which is not part of the paper, but just to place the paper into the big picture. So before I start, as I said, no enforcement practices under Article 1 or 2 that directly address algorithmic personalized price discrimination. So let me start with a brief definition. What is algorithmic personalized pricing? So I'll try not to call it personalized or algorithmic price discrimination, because some people might consider that this is not the right terminology to be used. However, because actually this practice allowed firms to move beyond traditional segmentation based on broad demographic categories, and instead construct highly granular consumer profiles, and based on that, they can price discriminate between different consumers. So when we think about the definition of algorithmic personalized pricing, this is basically a practice in which the companies collect and process intensive personal data, ranging from demographic information to behavioral and transactional information derived from online activities to generate individual prices. What company use is AI-driven algorithms to process this information. And based on that information, companies basically can personalize prices, and as a result, the same product might be offered to different consumers at different prices under identical market conditions. So in the paper, I'm distinguishing the algorithmic personalized pricing from dynamic pricing and targeted discount. So basically, the AI personalized pricing is a subset of algorithmic pricing. So I want to make clear this from the very beginning. So the dynamic pricing is not part of the paper.
That's why target discounts don't count.
So the focus of the paper is on personalized price discrimination because it's more profitable than target discounts.
Isn't target discount a personalized? It's not a personalized price. And it's a lower price for a particular person.
Yes, but I just want to be focused on specific set of algorithmic pricing, and that's why I said I'm going to distinguish from dynamic and target discount. So I'm going to be focused on only on algorithmic personalized pricing. So to start with, is this algorithmic pricing actually here? Some recent research indicates that companies are increasingly using AI-driven algorithms to process complex data. But the first experiment that I found, this is the famous Amazon experiment from 2000. So Amazon experimented with price discrimination for online DVD sales, but the consumers reacted very negatively to this. And Amazon had to apologize and had to withdraw the policy. As far as I'm aware, Amazon currently have a very strict policy against personalized price discrimination. So we have evidence that this algorithmic pricing already exists. And behavioral economy suggests that consumers' notion of fairness does not tolerate price discrimination, as I said, because they consider this as unfair. And whilst this personalized pricing is technically possible in digital markets, many firms will refrain from employing such practices due to concerns about consumer pushback and brand reputation. And this is exactly what happened with the Amazon case. However, implemented by dominant firms, in that situation, consumers' dissatisfaction is compounded by the limited ability to switch. So in some circumstances, consumers might switch, but if this practice is conducted by gatekeepers or dominant companies, that might be restricted. However, recently I've been experimenting with placing orders on Amazon, and I realized that repeat purchases lead to high prices. So I was very unhappy, and I stopped the subscription that I had on Amazon, and I decided to look around because the product that I'm buying regularly, it can be found anywhere. So I spent some time and I found the product. So I ordered the product, but next month when I needed the product, I realized that the price is 40 to 50% higher again. Then I had to do another search and to find another supplier. So I realized that there is a switching cost problem here, but this is not developed in the paper because I found out quite recently. So my focus is going to be in a situation in which a gatekeeper or a dominant company is using this algorithmic pricing and consumers don't have a choice. So of course, because I'm talking about price discrimination, I had to start my paper looking at the traditional economic theory of price discrimination. And of course, I'm describing in the paper the three different types of traditional types of price discrimination because I need to place the personalized pricing into some of these categories. And of course, the first degree price discrimination is when companies charging each a customer the exact willingness to pay, also called perfect price discrimination. And this type of price discrimination was considered difficult to be achieved in practice. But again, this is the old economic foundation, which is the pre-digital era. Then I'm going to explain how exactly this changed. So the second degree price discrimination, the price varies by quantity or product version. As an example, subscription plans, bundle deals, and quantity discounts and that kind of discounts. And the third degree price discrimination is when companies have some information so they can segment the customers into identifiable groups with different demand elasticities. And an example of this is student discounts, for example, senior discounts. And looking at the traditional forms of price discrimination, I had to place the personalized price discrimination in one of these categories. But looking back at the traditional economic theory of price discrimination, in general, economists consider this as pro-competitive strategy because it allows firms to extract additional surplus from consumers with higher willingness to pay, which results in transfer of surplus from high willingness to pay consumers to low willingness to pay consumers. It can increase output by lowering prices for certain consumer groups. And in general, it's an output expanding practice. And as I said, generally economists view price discrimination as pro-competitive. And this is particularly important and relevant for industries with high fixed costs, which helps companies to recover costs and to achieve economy of scale. Looking at the welfare effect of the traditional form of price discrimination, as I said, to maximize profit. However, the welfare effect depends on the market structure and consumer responses as well. In general, there is no general presumption of the effect of price discrimination. If we look at the economic literature, we would say that the effect is ambiguous, and based on that, it should be assessed case by case. However, I looked at some recent empirical simulation in digital markets. They do offer some evidence that actually personalized pricing can have a positive effect. So for that reason, we can't claim personal or algorithmic personalized pricing as a something bad per se. So for example, I looked at in one recent research, Schiller simulation study on Netflix subscription model, and it showed that implementing first-degree price discrimination based on consumers' web browsing data could raise the profit by 12%. But also the study reveals some information about the consumers, some of them paying twice as much as others for exactly the same product. So from this perspective, the effect, as I said, is quite uncertain and it needs to be assessed case by case. But in general, empirical studies on the effect of algorithmic price discrimination in digital markets remain quite limited, so we can't be sure exactly. So as I said, I looked at the traditional form of price discrimination in order to understand where exactly the algorithmic pricing fits. And I consider that, it approximates first degree price discrimination. You might argue with that and you might say, oh, probably it can be third degree price discrimination. But I was focused on the fact that first degree price discrimination involves charging each consumer a price equal to their individual willingness to pay. Pricing is based on individual data level and not group characteristics, which is based for the third degree price discriminations. And in algorithmic pricing, the prices are generated through behavioral and transactional inference rather than observable categories, which distinguish again from the third degree price discrimination. And for the paper, I'm focused on first degree price discrimination. That's why I call it personalized price discrimination. Of course, looking at the traditional conditions for successful personalized price discrimination, again, the focus is on first degree price discrimination. As I said, traditionally, historically, first degree price discrimination was considered difficult to be achieved in practice because companies don't have sufficient information about consumers. So basically, the three conditions to be fulfilled for a successful personalized price discrimination based on the traditional economic theory. First, the ability to segment the market based on willingness to pay, which is a lot of information about individual consumers. The ability to prevent or limit arbitrage between consumers. And of course, some degree of market power to set the differentiated prices. So this degree of market power, of course, cannot be confused with the dominance, which is the legal threshold. As I said, in general, the first degree price discrimination has been considered impossible in practice because of the lack of individual level information and inability to understand each consumer's willingness to pay. So let's see what happened with the algorithms in digital world. So how exactly the algorithmic pricing changed those conditions and actually made it possible. So now the most important condition, which is to have information about consumers in order to understand the individual willingness to pay, now is possible based on the huge amount of personal information that the companies collect and the algorithms process. Also, the ability to prevent and limit arbitrage between consumers. This is now also removed because in digital markets, this can be achieved through account-based access, device-locked content, non-transferable license, VPN, and geolocation controls, which means that in digital markets, the algorithm actually made the achievement of personalized price discrimination possible. So this is exactly what the algorithms actually changed. And going back to consumer welfare and fairness in algorithmic pricing. So if we consider the traditional form of price discrimination, they might be considered pro-competitive and enhancing consumer welfare. But I want to bring some behavioral perspectives here. So I found lots of empirical studies suggesting that fairness considerations significantly influence consumer preferences, trust, and willingness to engage in market transactions, factors that ultimately affect consumer welfare. And if consumers are not happy about how their personal data is being used, of course, that's going to, sorry, of course, that's going to affect consumer welfare. So the main point here is that the price discrimination is based on non-transparent and unexplained factors, and this is exactly what is perceived as negatively by consumers. If we consider, for example, third-degree price discrimination, consumers will accept this differentiated pricing, such as student discount, for example, loyalty schemes, peak time pricing, because they're transparent. And it's the same with the dynamic prices. You know, you're aware that if you're calling a Uber when there is a high demand, the price is going to be high. So there is a transparency, so you expect the high price. So with the algorithmic pricing, the consumers are not aware what kind of information, why they get this price for them. So basically, it's the lack of transparency that is problematic and the thing that consumers consider unfair. And of course, I need to place the main concern about algorithmic price discrimination. So the harm lies not necessarily in the price level, but in the process of how the price is set up, particularly when non-transparent data-driven pricing exploits behavioral biases or information asymmetries in a way consumers cannot detect, cannot challenge, so they can understand why the price is different. And as I said, lots of scientific papers, mainly behavioral economic, yes.
So in what sense are you assuming that consumers have to respond? Is it, are we talking about an essential facility? Are we talking about something they must buy in a particular quantity? Are we restricting ourselves to looking at that? But otherwise, we always have a choice not to buy or buy less.
Yes, but the moment you get the price, you have no information whether you're paying more than somebody else based on the information that they hold on you.
So this is exposed.
Yes,
So
everything is happening like in real life.
So this is why we never ask the person next to us now, actually pay for the ticket, because we don't want to have that regret.
Because there is dynamic pricing on the tickets.
With the tickets, yeah, we all experience that. We all experience that.
But there's a dynamic pricing on the tickets, so you have to.
So I don't think that is dynamic pricing because I can imagine that, you know, I'm looking for a destination and I'm looking for a specific day or time that I want to travel. I can't be convinced that like in 2 days the demand's going to be tripled and my price going to be tripled. So I'm not convinced.
No, I'm saying it's not. I'm saying that's what is more difficult in that case. You have a combination of dynamic pricing and personalized pricing. So identification of personalized pricing is more difficult than the other one because you have two components that are changing.
Yes, that's very true. But if you compare that situation with like you are using Uber, for example, you can see that there is a high demand and it's transparent. So you expect high prices. So you can choose whether to use the services or not. But when you're buying a flight ticket, actually you can understand that because, I'm personally not convinced. Like in 2 days, my price is tripled. I'm not convinced. And I've already booked the hotel. So they have information about that. So they know that I'm going particularly for these days.
And you can change IP in a way. If you change IP, they don't know who you are. They know your IP.
They usually do because you've had to log in or you're.
Yes,
I'm sorry, my phone's in sorry.
Additionally, is it really a reasonable step to expect people to change IP to not get a personalised? The bank don't personalise.
No, but when you get to the actual buying of something, you almost.
But the price you see is on the engine that you search.
We can say there are well-informed consumers that can try to circumvent the situation. For example, go incognito mode and do some other stuff. But we talk about the average consumer and the time they spend, because I've mentioned the switching costs. You can just spend time and time in order to locate the best supplier. And with the flights in particular, you need one particular flight, one particular destination in one particular time. So for me, it's not convenient to go in the evening. It's convenient to go in the morning. So basically, I'm stuck with this flight. Yes, I don't have much choice. So the focus on the paper is like personalized pricing implemented by a dominant company. As I said, consumers is limited, and only in this situation, I consider that transforming the perceived unfairness into competition law concern. And that's why I'm looking at a possible way to apply Article 102 to algorithmic price discrimination, considering that it is applied by a gatekeeper or a dominant company. So in general, Article 102 prohibits the abuse of dominant position, and this is going to be the legal basis for addressing algorithmic price discrimination. So as you know, price discrimination is specifically covered in Article 102C, which explicitly prohibits applying dissimilar conditions to equivalent transactions with other trading partners, thereby placing them at a competitive disadvantage. However, the MEO judgment from 2018 confirmed that this is about exclusionary abuse, and this is absolutely not applicable under the circumstances. So I looked at possible application of Article 102 that prohibits dominant companies from imposing unfair selling prices. And traditionally, Article 102A is applied to excessive pricing, price too high and unfair. With an unfairness, a core element of the legal test. So I was focused on the unfairness part of the test. But of course, we have to go back and look at the leading authority, the United Brands case, which established the so-called two-limb test. The difference between the cost incurred and the price charged for the product or service is found to be excessive. This is known as an excessive limb of the test. And the second element is the unfairness of the price. The price should be unfair in itself or whether compared to competing products. Of course, looking at the legal precedence of excessive pricing, or people would say it's very difficult in practice, and the case law appears very inconsistent, which was being criticized in academic literature. However, it reflects the fact that different methods can be used depending on the circumstances of the case. As I said, I will be focused on the unfairness part of the test. But let's start with the traditional excessive pricing case. If we have an unexplained price differences between individual consumers, we might consider excessiveness, even though the case law has never confronted individualized price differentials directly. So the case law is telling us that when the dominant company charges higher prices to some consumers than to others for identical goods, and there is no cost based justification, this probably can be a sign that the price is higher than competitive levels. So the comparison or the excessiveness test is difficult to apply in practice, and also the case law is telling us that there are different ways to assess the excessiveness. However, the demonstration of excessiveness is not sufficient because the decisive question is whether the price is unfair, in the sense that it bears no reasonable relationship to the economic value of the product. So this is basically the decisive element of the test. So basically, unfairness test is basically whether the excessiveness of the price that we already established can be justified. So because the price is abusive not when it's excessive, the excessiveness is not sufficient. But as I said, we have to consider also whether this price is justified, or there are no non-cost related factors such as consumer preferences that add value to the product, and as a result the consumer is willing to pay the premium price. And this is mainly illustrated in the Port of Helsingborg decision from 2014. So the Commission considered that the price is excessive. However, they found some non-cost related factors like consumer preferences, which means that consumers are happy, they're willing to pay the premium price. And for that reason, the Commission considered that the price is excessive but not unfair. So as you can see, the unfairness element was the decisive one. So this doctrinal structure, I think, is directly relevant to algorithmic pricing. However, algorithmic pricing differs in one crucial aspect. So the classic excessive pricing cases involve uniform prices applied across the entire market. So the excessiveness limits make sense as a threshold. In contrast, the algorithmic price discrimination generates individualized prices that do not raise the overall price level, but instead allocate different prices to different consumers without any product-related justification. And as I said, the harm does not arise from the surplus extraction per se, which may occur under competitive conditions, but from the process through which this surplus is extracted, non-transparent, individualized pricing that consumers experience as unfair and unjustified. And this makes the unfairness central. So as I said, the main arguments that all the paper is based is from the behavioral economics literature, which telling us that the consumers perceive non-transparent personalized pricing as unjustified and unfair. So in conclusion, algorithmic price discrimination has raised significant concern about the potential impact on consumer welfare. And I think that AI will potentially allow companies to extract a surplus from individual consumers. So the article argues that the harm, again, lies not at the price level as such, but in the process of price determination. And this type of harm is structurally very analogous to the unfairness limit in the excessive pricing casing. And for that reason, I consider that Article 102A can accommodate this modern form of exploitation, even though it does not fit the traditional excessiveness doctrine. So the paper was focused on whether algorithmic price discrimination can be tackled with Article 102A, but I want to give you some recent development in order to put the paper into the bigger picture. So when I completed the paper, I wasn't thinking about recent developments. However, I looked at the joint DMA GDPR guidelines, and I submitted a response to public consultation. And looking at the regulatory scope under Article 5.2 of the DMA, I see that it restricts combination, cross-use, or profiling of personal data across services. And I consider that this is exactly the same data processing operation that are the foundational inputs that enable actually price discrimination. And then I looked at the draft joint guidelines about the consent architecture, and there is a specific purpose-specific content. For example, you have to ask consumer for their consent, how their information is going to be used. For example, content personalization, advertising personalization, and the algorithmic personalized pricing was not recognized as a distinct purpose, which for me is concerning. But I think even if it was recognized, who can consent to personalized prices? I won't, for example. So from this perspective, I consider that personalized price discrimination, it can be a regulatory issue as well under the circumstances. The other recent development. So I just wanted to give like the bigger picture what's going on at the moment, because I consider that you don't follow everything that's happening around that. So currently, the UK government opened a public consultation to change the competition law regime. The public consultation is currently open. I also submitted a response to the public consultation. So I can see that for the first time, algorithms are considered, and basically it is considered to be granting the CMA enhanced power to invest algorithms. So I specifically copy and paste sections of the draft text to show you that CMA now is considering that algorithms are problematic and they have to be looked into more deeply. But as you can see, to facilitate collusion, which is like the main topic in which AI algorithms in general are considered. And then the second part of the paragraph is to charge varying prices for the same product based on personal data, on protected characteristics and vulnerabilities, which is exactly the algorithmic price discrimination, but it is considered in breach of consumer law protection only. Right? It's not considered as a breach of competition law provisions. However, I attended a workshop last week in London, and the topic was algorithmic collusion, and someone from the CMA was one of the panelists. So I said, considering the current consultation, is that related only to algorithmic collusion or more broadly? And the response was yes, more broadly. Okay. So from the text, to me, it's not clear whether they would consider also competition law breaches, because I can see only breach of consumer law protection. So about the powers. So I specifically copied and pasted from the text. Require person to obtain or generate information on algorithm, including require businesses to produce simulated outputs. Require persons to vary their usual conduct, for example, altering how services or digital conducts are presented to user to better understand algorithmic behavior. Requiring person to perform basically the power of the CMA, what the CMA can ask during the investigation. So in my response to the public consultation, I consider that this abstract simulation or demonstration detached from defined theory of harm will not reveal whether consumers are systematically disadvantaged, not whether pricing outcomes reflect legitimate differentiation or exploitative discrimination, because simulation is not going to work in my view, because this is happening like in real world scenarios. I don't know how the CMA is going to implement. I don't know how they're gonna change the draft, but in my response, I was quite clear that I have some concern because, you know, they don't have clear theory of harm, how they're gonna base and how they're gonna benchmark the results of this simulation. So this is my main point here. And finally, the draft implementing act on the AI regulatory sandboxes under the AI Act. So I know lots of people here are very familiar with the regulatory sandboxes, and you're aware that Article 57 of the AI Act requires member states to establish at least one AI regulatory sandbox. You know that these sandboxes are intended to provide control environment, and I consider that algorithmic price discrimination is a very good fit for sandbox testing. So I provided a response to the public consultation, and I used my paper on personalized price discrimination as a test case study for sandbox testing. And I realized that there are some structural limitation of the sandbox framework. So basically, I'm not going to talk about that, but like voluntary nature or like more than one authority responsible to, you know, overseeing simulation. So as you can see, looking at the algorithmic price discrimination is gray area. There is no enforcement. It's not considered under the DMA. And I'm just trying to put the this paper into different context, but I can see that I have lots more to do. However, just a little bit about work in progress, because I consider that what the CMA is suggesting is not going to work, and I think that we need like a detection tool to, you know, to detect personalized price discrimination. And I looked at the existing research, and there is no developed method that is capable to detect algorithmic price discrimination or to distinguish when such practices are perceived unfair by consumers or whether they occur in the presence of market power. So we don't have information, it's underexplored. And I'm developing a project, and the objective of this project is to empirically test whether undertaking with gatekeeper position deploy algorithmic price discrimination to develop an AI methodology that is capable of detecting. So this is like a work in progress project. The project is going to be based on natural language processing using the BERT topic as a screening tool. And that's going to help us to analyze large-scale textual data to surface pattern and combine topic modeling, sentiment analysis, and temporal tracking in order to understand whether this is happening in practice. On this project, I'm working with an AI expert from the University of London Business School, Dr. Mandis Gaugari. So we're developing this, and hopefully we're going to apply for research funding for this project. So I just wanted to, you know, after presenting the paper and my theory, just to put the paper into the bigger picture, what's going on at the moment and what's my future plans are. So thank you very much for your attention, and I hope I'm going to have good questions, because the paper is under review, it's not published, which means that I still have time to, you know, accommodate some comments and to change and to improve the paper. So we finished just on time, so we have lots of time for questions. Yeah.
I think the problem with this sort of analysis is that it's assuming that consumers already have clear preferences, which is not only, I mean, I think, and it seems to me that this one, I thought when you talk about CMA and their simulation, I thought that was definitely the way to go. And the reason is because where it seems to me that these personalised pricing is harm. It's not so much unfairness to individual consumers. It's undermining the way the market works. And so that if you're as a consumer, you need to be able to compare prices. Take your example, you know, to the airline. You want to not only when you're thinking about, do I want to get a flight to Florence, you're also thinking, well, how much it's going to cost to stay in a hotel in Florence, how much it's going to cost to go for a restaurant in Florence. If all of these are simultaneously personalising their prices, so in other words, what it's doing is it's undermining the basic function of the price system, which is to enable people to make sensible plans. And if that's the case, it seems as though what you need to be doing is, and you ought to have a principle which is enforcing a sense of sort of publicness of pricing, i.e. transparency, so that it's not the unfairness of the non-transparency, it's the fact that it's undermining the working of the system. And so the methods that the CMA are proposing are methods of investigating whether the prices are transparent or not. So I think that's the way to go.
Well, so what the CMA is suggesting is to enhance their powers to collect information about how companies use algorithms and what kind of information to ask, because
what's information to ask surely is would people with the same circumstances putting in the same information, would they get the same price? And you just say if there was an understanding that was not allowed, if the principle was you're not allowed to do that, then it would be very useful to be able to.
Yeah, so I consider that the simulation that the CMA is considering as an option is not going to work, because we need like a real world scenario. And that's why I consider that sandboxes might be better fit, because using regulatory sandboxes, you can test the AI tool that the company is planning to incorporate, like in the real world scenario. So you can see the effect on consumers, like yeah.
One thing that would be interesting to see if it, in the sandbox, it came up with the same answer every time. I don't know if there was a lovely article about Michael Ronson's wife in The Guardian, and it kept on, every time you asked it, it came up with a different suggestion. So AI is, as we know, is very stupid, and he couldn't do it. And he consistently couldn't do it. And so you wonder if it's going to offer the same price to the same person when asked the same question without updating. So this is the third time I've asked it, just asking it on these facts, what price would you say? And if you can't do that, then you can see why firms would be extremely reluctant to do this, because they have no idea what's going to happen. But more generally, one of the things when we talk about fairness, one of the difficulties is you talk particularly about cases where there are significant fixed costs. So one of the argument is that we can use price giveness to ensure that we get fixed cost recovery. And that may actually mean that a product that otherwise wouldn't come on the market at all is put on the market. What exactly is the fair way of recovering this fixed cost from prices? And the uniform price is not obviously fair. The Ramsey pricing, which is the way we normally do it, is efficient, is often extremely unfair because people who are less flexible also fall. Maybe we want to get it from the rich, but then we don't like doing that, as the CMA found in care homes, because the people who were disadvantaged by the first-class pricing were the rich. And they didn't like that either. So, and neither could want to do it. So, what exactly, how do we even reach an idea about what a fair price is if we are trying to engage in fixed cost recovery?
Well, so as I said, I looked at recent research trying to identify algorithmic personalized pricing, and most of the methods that we use are like simulations, which means that we can't observe consumers' behavior in real time. And looking at the evidence that I found from the behavioral economics, consumers are genuinely unhappy when they can understand how the price is formed, based on what, and they consider this unfair. So there are lots of empirical surveys that are giving us very strong arguments, and I consider if consumer is not happy, this affects consumer welfare and needs to be considered. Yeah. I know that unfairness is something that lots of people would say it's difficult to be, it's too abstract, it's difficult to be
I just hear the 5-year-old. It's not fair. And, I mean, look, it's more seriously. Okay, so what are they going to do about it? So we know that in some cases people do something about it. They do all future purchase for the same supply. One of the reasons Amazon was truly worried about it was that people don't just buy once from Amazon, they buy all the time. And if in one case they feel that they were being unfair, they may not buy from Amazon, even if it wasn't Amazon who set the price as well. Now that makes sense.
Well, so about the unfairness, I will think about the unfairness test of the United Brands and how exactly was implemented this in practice. So basically, the consumer will consider the price unfair if there is no added value that makes the consumer want to pay the premium price, right? So this argument was recently used in the recent class action case in the UK, Kent versus Apple. So basically, the court considered that consumers are not happy to pay the premium price, and that's why the price is excessive. And using the same argument, the court rejected the claim in La Paturelle, saying consumers are loyal to BT, and for that reason, they're happy to pay premium price. So we can juggle basically with the unfairness and the consumer preferences, but basically looking at the jurisprudence, when the price is unfair, it's something that is a price that is not justified, or there are some non-cost related factors, which makes me happy to pay the premium price. Yes, this is expensive, but I'm gonna get something more, so I'm willing to pay a premium price. It's about the premium price. That's why this doctrine is not applicable in the excessive pricing case, the pharma industry, because consumers, the patient cannot say I'm happy to pay premium price. So this is not applicable basically in this sector.
I'm just wondering how often the consumers are aware that they're getting a different price. I mean, and also I want to introduce the fact that we're not talking about pricing based on, this sort of standard ability to pay and how locked in are you, how much are you likely to choose another option, because the amount of data, the type of data they have, especially if they're operating through a conversational recommendation agent, is that they theoretically could be pricing based on the emotional state that is detected of the user at that time, right? As opposed to somebody else on another time in another place, like very, very specific things could be taken into consideration.
We don't know what type of information they hold and what type of information they used in this for the algorithms to get to the individualized price. We have no idea. So that's the thing that consumers consider like disturbing and feeling like unhappy about it.
We've got a question online from Tanya.
Yes, hi, thank you. It's a really fascinating presentation. Thank you so much for that. I've got one sort of observation and one question. The observation is that sandboxes seem to be quite onerous in terms of or resource intensive if we think about this as an issue that will permeate the entire economy. So every other retail business or every retail business will shortly use AI in order to support pricing decisions, product design, marketing, etc. So my question is, how will a sandbox support developing rules? And then the second question I had is related to that, which is that when I was working at BT Group, I was working on the Le Paturelle case, and it relates to the uncertainty that comes from a fairness test that can rely on so many different methodologies to determine what is fair, and what you think that could do to competition law and the predictability that competition law provides for. Because ultimately, if it is to be a deterrence of bad behavior, then firms need to know what bad behavior looks like. Thanks.
Yes, thank you very much. So I'm going to start with the sandboxes question. I also was very surprised to see that the implementation AI Act is focused on small and medium-sized companies, which I criticized. And this is also related to your observation. It's time-consuming. It's very difficult to be done. And one of my recommendations was like better, you use big companies because they have lots of resources, lots of data. However, it's the framework is focused on small and medium-sized companies. The other problem is, as I said, the voluntary nature. The other problem is that in some cases, more than one authority might be best place to run the sandbox, and there is no clarity. So there are lots of unclear information from that. So I completely agree about the sandbox testing. So the other question about the unfairness test, I agree. Currently, the excessive pricing test is quite confusing for companies, and the main concern is like a lack of predictability and how exactly the court is going to approach the question. I've been studying excessive pricing and jurisprudence for some time now, and specifically in the UK, most of the cases are in the pharma industry, and I criticize heavily, how the court developed the United Brands test, and how difficult it became, because looking at the pharma cases, you can see that the unfairness test now should be unfair in itself and compared to competing products, and this is clear departure from the EU jurisprudence, because it's either the first limb or the second, but in the UK become like not alternatives, but they have to be looked together. However, I think that the class action case in the UK, actually, they're bringing more clarity to the excessive pricing jurisprudence rather than the CMA cases. But as you can see, that the unfairness limb of the United Brand test is the decisive factor. And I think that both in Lopatrel and Canvas Apple, it was the consumer preferences and their willingness to pay premium price. That was the decisive element, actually, not the level of the excessiveness of the price. And when I talk about excessive pricing everywhere, I advise don't start with estimating excessiveness, because it's very expensive and very difficult exercise. Look at the unfairness test, and if you can find some cost-related justifications, if you can find some non-cost-related factors that can increase the value of the product, then you go back and do the expensive exercise. So this is my practical advice here, because if you spend lots of time and money to do the excessiveness and to prove that the price is excessive, this is not enough, and you still can lose the case because you don't have sufficient clarification about the unfairness. So we a little bit, moved into, that kind of discussion. But at the end of the day, I'm suggesting application of Article 102A, and we have to consider the both limbs of the United Brands test. And as I said, we need to be focused on the unfairness, because this is the core element of the test here.
So one thing I think is important I have 3 points I want to make. One is, it seems to me this is a market where a platform could enter and, gain into the market, because you have a consumer A and a consumer B. They offer two different prices, and in principle, you can ask consumer B that is offered the high price. The platform will say, I ask consumer A to buy for consumer B, and they share the difference. okay? So it's a market that in principle can be exploited by a platform, but it's not, supposed to be. We have, the price comparison website in this market that they act as intermediary. In principle, they do not decide the prices, but therefore, how do they know that they're, as an intermediary, how do you know that the price that the consumer A is going to see is going to be different than the consumer B if you're simply an intermediary in the process, a price comparison website? But maybe this is something that we're talking already when there is not really this abuse of dominant position. It does work on markets when there is some sort of competition there, so there is some filtering going on. But then what about the airlines? In the airlines, there should not be personalized pricing in the airlines because in the airlines there is competition in this market. There are intermediaries with the price comparison and the potential for a market to be exploited by someone. So there is this aspect, I want to bring it up for discussion.
That's very true. The market is competitive, but as I said, when you're planning a trip, you usually want specific dates and specific time of the day because everything else is not convenient for you. Either the airport is too far away from you, or you don't want to fly in the evening. So basically, you don't have much options.
It depends on where you're going, because a lot of places I go, only Wizz Air goes.
Yeah, but
We don't have a choice.
Yeah, so but that can be looked at, but that's exactly the point I'm trying to make. How competition, for example, affect this, if you want, these personalizations or not. That is one aspect that you can look. If you're looking on the airlines, is it a route that only one airline does? They don't have a monopoly there. Therefore, there's one they can exploit more the personalized pricing. Or there are two competitors going in.
Yeah, for some routes, it might be like one monopolist who is only serving the route. Yeah.
The other is an important aspect to look. It might have been looked into the literature, but I'm not aware of that. Is how does it matter when you are, for example, with Facebook, that they know the network of people that they connect with each other, or WhatsApp, there is a network there. And what if you produce a personalized price to somebody in the network versus you produce a personalized price to somebody that's not in the network, that therefore there is less information about what is going on, there is less treated of unfair or unfair, because I don't know, I don't talk to somebody outside my network, but I talk to somebody inside my network. So there is this component that to look
there are so many assumptions here. As I said, there is no clear methodology that's been developed. So that's why this is the next step that I want to do, like to develop an AI-driven detection of personalized pricing. And I just want to focus my work on that because, as I said, I'm personally affected as a consumer. So I want to finish this project and I want clarity. And hopefully my work is going to bring some clarity,
And I bring a third point, which is I think is most important here, is when we talk about exploiting, personalized pricing, getting the maximum willingness to pay a consumer, this really credits Bob thinking is, what is the maximum willingness to pay of consumers when they don't observe the price? So you form your willingness to pay typically by observing the prices as one important piece of information to you, and you get the maximum willingness to pay based on that information. You take that information away because you're giving you the price you observe your maximum willingness to pay. There is something circular there that it seems not to be working. But
yeah, possibly. I have no answer for that. As I said, I did some experimenting, like with booking tickets, and then with some other products of Amazon. What I discovered is troubling for me, and it's happening. It's happening.
So my question is about the first limb of the test. So you decide not to focus on the excessiveness, right? But I wonder if personalized pricing can also be problematic for the first limb, because if we use a cost plus approach, we have a problem of defining what the costs are, and I guess it's quite difficult when we have a lot of very low prices where clearly the company is not recovering the costs. For instance, I booked a flight for £4. For sure, the cost is not recovered there. And if you don't use the cost plus, because maybe you really don't manage to understand what the cost actually is, you use the comparator test, then again, you compare against a lot of prices that are excessively low. So you can say it could be possible to produce this service, to offer this service for a very low price. But then you compare against other, for instance, airline companies that sell again prices for £4, where the cost is not really taken into account. So how can you actually determine excessiveness? And I wonder the fairness problem is very relevant, but I wonder if you can extend your research to also encompass the first limb of the test?
Yeah, so as I said, the excessiveness limb of the test is not quite applicable here because we don't have excessive prices across the board. We have like excessive prices towards individual consumers. But because you mentioned the cost plus test, actually, it is the first part of the United Brands test, but looking at the EU jurisprudence, it's been used twice. Court of Helsingborg and Aspen, which is a commitment decision. It's not even part of the case law, right? Which means that the jurisprudence is telling us that you can find other ways to prove excessiveness. You don't have to do the price cost plus test, right? You can use comparison with different geographic areas. You can use comparison with different products. You can use comparison. So looking at the jurisprudence, there are different methods to prove excessiveness, and the cost plus test is, as I said, only twice used.
Surely the algorithm can check that out by just making sure it takes into consideration the prices. If it's really that smart, which slows down, it should be able to do that.
Potentially. Yeah, a couple of reflections. So first of all, on the type of data that's being collected to do this type of pricing, I do wonder if it's only a competition concern, but also like a GDPR fundamental rights problem. So if you are doing more research and finding out the type of data they're collecting, it might be that they're getting to a point where it's starting to conflict with things like a right to not have decision making done by entirely automated means without human in the loop, or a right to have erasure, or so there might be a more fundamental rights issue and a GDPR issue with this type of pricing activity rather than just competition policy angle. So, people, talking about fairness, people have it's fair to respect people's fundamental rights.
Yes, it is 100%. This is why I submitted the response to public consultation to say that, okay, so the gatekeepers, are not allowed to process personal data without asking consumers, and they have to specify the purpose they asking, under the GDPR. And content personalization, advertising. So basically, you need to give your consent that you are happy that your personal data is used for example, advertising personalization. But for pricing related, it's not there.
Exactly.
It's not there, and this is something that affects consumers' pockets on a daily basis, right? Yeah.
This is something that maybe we can pick up also over lunch. But the Digital Services Act requires the very large online platforms to mitigate any risks to all fundamental rights, including consumer protection, which is one of those named, and of course, privacy data, everything related to data protection. And so not all of the BLOPs are gatekeepers under the DMA, but they have these systemic risk obligations under the DSA. So it could be that there's an avenue to require them to address it.
I'm waiting another public consultation. So basically, my concern is that personalized price discrimination can be found anywhere. It's not considered anywhere. As I said, the first occasion in which I saw someone is taking algorithms seriously is, the CMA's work on enhancing their powers. But it can be seen, and for me, this is a problem that I can see from consumers' perspective. And hopefully with my work, I'm gonna bring this topic into the, attention more widely, and hopefully something's gonna happen in the near future.
Yes, I have one observation and one question. In terms of observation, I come up with one of your slides saying that algorithm pricing can be excessive or unfair to someone, but it will not increase the overall price. I think that's correct, because in one line of your slide, because I don't think there's a case where they can charge a lower price for low willing to pay. That we check excess price for high willing to pay. And that cannot bring the price lower in terms of overall price, but it will keep increasing. I don't think they can charge a lower price for low willing to pay consumers. So
That's the presumption.
Yeah. Okay.
that's the presumption that they're gonna charge some consumers low price, some consumer high price. But my theory is that we don't care about the level of the price as such here. So my theory is based on consumer perception of fairness and the lack of transparency on how their personal data has been processed. So this is my main argument, and I'm focused on the unfairness element.
And one question about your next project in terms of you try to use AI to detect pricing. Do you think about a case where there can be AI supported for buying decision? Because I can think a lot of scenario where, for example, the first case we as consumer, we try to buy something. They sell at the price of like AI enabled price, so we buy it anyway. So excessive and unfair for us. Second, we might, I feel like there's something wrong here, and I wait until 1 or 2 days later to see whether the price can be lower, because I know that at that time they know about my decision about hotel and other things. They know that I will have to go anyway.
Exactly. Yeah.
But I can still wait until tomorrow to buy the ticket for like 1 month later.
But the thing is that the price I experimented a lot.
And the second, and then the third thing, I think maybe we can use AI to support us in like, should I buy this or can you change the IP? Like, because
yes, you can change, but as I said, we talk about the average consumer, not like high.
So just the first one, right?
Oh, so that's
buy immediately.
Yeah, so I'm well informed. I still can do stuff to try to circumvent, but I'm still not successful, because as I said, I did a lot of experimenting, and I ended up with the price tripled, like with a time frame of like a week or so, tripled. The moment I booked the hotels and the moment I bought, some other stuff to show that I'm going this specific time, so the price was tripled, and I experimented many times. It's just happening. And just to let you know, there are companies at the moment, I'm aware of that, they are specializing at developing AI algorithms for personalized pricing. This is their business. So you can be like a small business or medium-sized business, and you can buy this product from these companies. So you can use algorithmic price discrimination in your business. And I think last year when I was developing the project, I found information about 2 senators in the States questioning the one company, Delta, accusing them by using AI algorithms to personalize pricing. And the company publicly announced that actually they don't use that, but they do dynamic pricing, which was not true, because the initial announcement in the media was that they use algorithmic price discrimination, and they use a specific company that helped them to deliver these algorithms, right? So I think that we have clear indications that this is happening, and that not only big companies are going to use these algorithms, but also it's going to be available for small and medium-sized companies, because it's not going to be difficult for them to purchase the product from the company specializing in that. So
I think we'll have to round it up there to let everyone get to the next meeting. But just like to thank Mira for her contribution today. Some of you are going to lunch with us, so I'm sure the conversation will continue.